As part of Fox 17's continued coverage of Pride Month in West Michigan, today we're talking about the often difficult conversation around estate planning and how it can be further complicated for LGBTQ couples. Our Michael Martin spoke with a legal expert on what people should be aware of when making plans to take care of their loved ones after they're gone.
The little step of having a plan in place goes a long way to ensure that your family is able to focus on grief and emotional healing after death and not having to worry about what you want, what your plan should be.
It's something no one particularly wants to think about, making plans for what happens when you or a partner passes away.
There's no other way to go about it. It can be incredibly difficult to have a period of mourning or loss, of grief, and then on top of that have to be dealing with legal complexities and probate and estate planning and figure out these intricate details.
For those in the LGBTQ plus community, the legal complexities that come with not having an estate plan in place can be severe, as many default estate laws were written based on past definitions of marriage.
Those default laws may say blood relatives have priority if you are not married. And if you are in a same-sex relationship but not married, or any relationship but not married, that may not be the results you want.
Patrick Hicks with Trust and Will, an online company that can create child guardianship documents, trusts, and wills for couples online, says there are two specific items that LGBTQ plus families should seriously consider getting in place.
We firmly believe that every adult needs a basic estate plan that includes a will and a set of healthcare documents that plan for incapacity during your lifetime. If you do not have a healthcare directive and you are in an unmarried relationship, your partner may not have any legal rights to care for you or make decisions on your behalf. You must have that documented.
He says without specific legal directives in place, a couple could even have issues with their children when a partner dies.
There are many same-sex couples where there is one biological parent and the other parent is not a biological parent and they have not yet legally adopted the child. Without that legal adoption in place, that non-biological parent may have no legal rights to care for those children if the biological parent were to pass away.
With these documents squared away, you can feel secure that your partner, your children, and loved ones are accounted for should the worst-case scenario happen to you.
The topic can be tough to think about your own death, but an easy way to approach it is to spin this and reframe it and think about what is it you're doing for your loved ones. You're doing something to ensure that your loved ones are cared for in the future.
Michael Martin, Fox 17 News.